Well, hello everyone, and thank you very much for joining me. My name is Lior Samfiru, the employment lawyer. You know me, you've seen me before, and welcome to my live stream session. This is where you find out about employment law, workplace rights, where you get to ask questions, get answers, and walk away with the knowledge that you need to have. Again, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. If you're an employee, you have an employment law question, I don't know that you can do better than us across Ontario, BC, and Alberta. We're here to help. We provide information. We answer questions. We empower you with the knowledge that the law is on your side when it comes to employment law. Law is on your side if you lost your job. You have entitlements. The law is on your side if you're being mistreated by your boss, by a coworker. The law is on your side. There's if your job is changing, if you're put on a temporary layoff, if you're being forced to sign something, if you're being forced to resign, in all those situations and many, many more, yeah, the law is on your side. There's rights, there's entitlements. There are things that your employer can't just do. And on this session, every week, I talk about those things. I answer questions. I make sure that you have your workplace questions resolved. So don't be bashful. You have time. We just started this session. I want you to ask your question. I want you to make sure that you feel better. Don't go ask your neighbor or your grandma or Google what the answer is. Ask someone that knows. Ask someone that does this for a living. Ask me right now, and I'll tell you what you need to know about employment law. And I'm Lior Samfiru, the employment lawyer. And before I get started with questions today, let me give you some other contact information. This is a 30-minute session, but beyond this session, I'm not going anywhere. You can reach me by phone, by email, by fax, even by pigeon, I think. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information is right there to reach me, to connect with me and my team, to learn more about employment law, kind of your one-stop shop to get those workplace issues solved. Again, employmentlawyer.ca. But right now, you don't even have to remember that. Right now, I'm here with you live answering questions. Lior Samfiru, that's me, the employment lawyer. So I say we start answering questions. As you listen to me answer someone's question, you want to listen to that. But even as important, or even more important, ask your question too. Make sure you get some answers. All right, let's start answering questions, shall we? First question today. It's from Wyatt. Wyatt is joining us from Facebook. I was recently denied a job because I had a consumer proposal, on my credit history. Is this legal for an employer to do? Can an employer use credit information to deny a position? So there is no law that says your employer is not allowed to consider that. It may make no sense. It may be a bad idea. It may not be a decent thing to do. But the question is it illegal? There's no law that says your employer cannot consider credit history in deciding whether to give someone a job. Now, they may be walking away from a very good candidate, a very good employee, and that's a bad move. But the fact that it's a bad move does not make it illegal. Now, there are things that your employer cannot consider when deciding to let you go. Oh, sorry, not to let you go, when deciding whether to offer you a job. One of those things may be your record of offenses. If you have a criminal history and that offense has been discharged, you've received a pardon with respect to that offense, then that cannot be a consideration. Another thing, of course, is your age or your marital status, your ethnicity. All those are illegitimate considerations. They're illegal considerations. Your employer should never consider that or even, frankly, ask about that when it's offering you a job or interviewing you. But in terms of your credit history, not a nice thing to do, I agree, but also not illegal. Okay, I hope that makes sense, Wyatt. Any follow-up questions, I'm right here. Feel free to ask. And of course, I will answer. Great question right there. Good answer right there. If you've just joined me and you want to know what is this thing, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here live answering your questions. So ask your question. Don't be bashful. I see questions have come in. I'm going to continue answering them right now, so I'm going to get to yours. So ask it. Brian has our next question. My employer has been decreasing my hours over the last few weeks, and I'm now down to a 3-hour shift per week. after working full-time for 2 years? Can my employer just continue to cut my hours and force me out of the job? Well, here's the thing. It's not legal to do what they're doing. But the fact that it's not legal does not mean there's a way to physically stop them, to restrain them from cutting your hours. What this means is you have the right to consider this reduction in hours to be a termination of your employment. We call this constructive dismissal. And you can then force the company to pay you severance. Here's why you want to do that. If you don't do it and you accept this reduction, now you only work 3 hours a week, and let's say a month later they let you go. Now the severance they're going to have to pay you is going to be calculated based on 3 hours a week because that's all you're working. Don't do that, okay? If you're going for full-time to 3 hours, done. It's over. There's no point to continue. Unless your employer confirms it's only for a week, fine. But if they're just reduced your hours, no. Constructive dismissal. That way you can get your severance based on your full-time hours. And of course, if you accept this reduction and continue working, you've given them the right to reduce it further, to do it again. Terrible idea. Don't do that. Okay, so Brian, here's what you need to do. Immediately. Time is not on your side here, okay, because they've already done it. You want to connect with me and my team as soon as possible. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca, the place to do that. And of course, when you go there, contact information is there. I want to talk to you. We talk exactly how we get out of there, how much severance you're owed. You've been there for a couple of years. You could easily be owed a few months, not weeks, months of severance. Okay, so you know what to do, Brian, employmentlawyer.ca, and we'll get going on that. Very good point here, by the way, for everyone. If your employer reduces your pay, changes your hours, demotes you, all those things may be illegal, constructive dismissal. But if you don't do anything, you kind of put your head down, you're the good soldier, and you continue working. By doing that, you've given them the right to do it again. And potentially, if they let you go down the road, you're going to walk away from a lot of severance you would otherwise be owed. Not a good thing. Before you accept, before you continue working, let's chat, okay? employmentlawyer.ca. Fantastic question. Love that question. Thank you for that. I'm going to continue answering questions right now. I see questions now come in. By the way, if you're just joining us and are wondering what I'm talking about, well, I'm talking about employment law. I'm talking about workplace rights. My name is Lior Samfiru. I'm the employment lawyer, and I'm answering questions about employment law. I'm telling you what you need to know about workplace rights. So ask your question. If you want to know something about the law, about your rights, ask it right now, live. There's a box on your screen. Type in the question, hit enter. It's going to pop up on my screen, and then I'll read it and answer it. All right, let's see. Continuing to answer questions. Saga World Boss has our next question. I work for Hudson Bay. They plan on closing most of its stores, but they're keeping 6 open. They filed for creditor protection. I asked HR if they would apply for WEP. They said no. Okay, there's no question, Saga World Boss, so I'm not sure exactly what you're asking. So if you have a question, by all means, please ask it. All right. Next question comes to us from Sir. I have proof that I was rejected from getting hired because of my skin color. The job I applied for didn't indicate the wage, but I'd like to claim damages. Is the employer obliged to share what the compensation would have been? Yes, absolutely. The key is not that. The key is how can we prove that you weren't considered or hired because of your color, because of your race or ethnicity? Because if that's what happened, it's illegal. As I was saying earlier, they cannot avoid hiring you because you're white or black or any ethnicity, any race. It's illegal. But of course, it's not easy to prove that. Keep in mind, your employer is not going to admit it. They're not going to say, yes, of course we did it. So you need to have some other proof. If there's a way to prove it, yeah, that's an easy case. There's human rights damages, what we call general damages. There's loss of income. It's a big deal for a company to do that. And if you can prove it, it's not even going to be difficult to resolve. So always the question, sir, is proof. Can we prove it? You say you have the proof, so let's chat off air. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. When you go there, you'll easily be able to find the email address if you want to email me, the phone number if you want to call. It's all right there for you. So yeah, let's have that chat. It would be completely wrong, completely illegal for an employer to do that. Let's not let anyone get away with that. All right. So you know what to do. Look forward to connecting with you and helping you. All right. Fantastic questions. I see another one here. I'm going to answer it. But hey, if you're watching, what are you waiting for? You got time. You can get the questions just phrased the way you want it, and I'll read it and answer it. If you ask a question right now, I guarantee you'll get an answer during this session before I'm done today. So let's not waste this opportunity. Take advantage of it and ask your question and make sure that you know what you need to know. Again, Lior Samfiru, that's me, the employment lawyer. All right, I want to get some more questions answered. Renee, or Rani, maybe Rani. My parent is not well. I asked for accommodation to temporarily work from home. There's nothing in my role that I have to be in the office. My employer says I should resign or go on an unpaid leave. No. So here's what you need to do. Ideally, you can get a letter or a note from your mother's doctor saying that you're a care provider and that your mom needs you around at home, but you can still work from home. In other words, she doesn't need you 24 hours a day. It's not like you have to be there all the time. You're able to work from home. If you provide that note, your employer has to accommodate you. They have to. If it's possible for you to work from home, they have to do that. If they don't, that's a human rights violation. If you cannot get that doctor's note, you can't get to the doctor won't give you a note, put that yourself in writing. Send a note to your employer, an email, something in writing where you say, I am my mother's primary care provider. For medical reasons, I need to be with her during the day a few times. I need to be able to provide care. I can still work remotely, so I'm asking you for accommodation. If they don't accommodate, call me. Once they hear from me, quickly, very fast, they'll accommodate. You'll see how quickly they'll accommodate. An employer has to accommodate based on what we call family status. So if your mother requires care from you, and you really you're it in terms of providing that care, your employer has to allow you, give you that flexibility or working from home to make that happen. So Rani, now you know what to do. If your employer won't accommodate, reach out to me. I'll take care of it, okay? Employmentlawyer.ca to connect with me. Happy to help and wishing your mother all the best, of course. Thank you for that. Randy had a follow-up question. Can I go visit my parents back home if I am on STD with depression? Yes, you can. There's no reason why you could not. But keep in mind, that doesn't mean that your insurance company may not give you a hard time about it. They might. If they do, call us. We have a team that can help you with that. All right, I'm Lior Samfiru, by the way, the employment lawyer, of course, with Samfiru Tumarkin LLP. I'm seeing a couple more questions that came in. I want lots more questions. I don't want a couple. I want 20 more. I want lots of questions to answer. So please, it's not a bother. It's what I want to do. It's much better for me if I have lots of questions to answer. So don't be afraid. Ask your question. I promise you I'll only give you answers. That's all. All right, let's continue, shall we? Next question comes from Anita. Anita asks, what can you do if your employer starts suggesting it is time for you to retire? Are they allowed to change your job duties because of this? No, they're not. So if your employer says to you, it's time to retire, I want you to send an email, okay? Because it needs to be in writing. Saying, employer, you said a few things to me about retiring. I just wanted to be clear, I have no plans to retire. If I change my mind and I plan to retire, I promise I will let you know. That's it. End of story. If your employer does anything to you beyond that point, that could be a human rights violation. That could be a constructive dismissal. If they even keep bugging you about retiring after you send that email, that alone could be a human rights violation. Okay? So no, your employer cannot change your job because of that, or really for any reason, potentially. So, but I want you to send that email. So I want you to be clear with them in writing, not retiring, leave me alone. You don't have to say leave me alone, but it needs to be clear, this is it. I'm not retiring, and if it changes, I'll let you know. Bye. Done. If they do anything to you, that's a big deal. Could be age discrimination, all right? I want you to connect with me immediately if that happens. Send that email for now. Of course, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. A very good question, Anita, and I hope that this resolves it, but you know how to reach me if you need to. All right, let's continue. More questions, ask yours. Terrible T has the next question from YouTube. How much notice does an employer have to give you when requiring overtime work? Are all staff required to work overtime? So generally speaking, you're not required to work overtime unless you sign an employment agreement that says that you will. So if you sign an employment agreement that says that you will work overtime anytime we ask you to, well, they have to, they have a right to do that, and you have to work as long as they give you reasonable notice, but that's not a lot of notice that they have to give you. If you didn't sign something like this, then you don't have to work overtime. But I want you to keep something in mind. Remember the general rule. An employer can generally let you go at any time and for any reason, as long as severance is paid. So in theory, your employer can say, well, you're someone that doesn't want to work overtime, so we're going to let you go. Now they're going to have to pay you severance. That's not a for-cause termination. That's not a resignation. That's a without cause termination with severance. Why can they do that? Well, because they can let you go for any reason as long as severance is paid. So something to think about. Could it be that you lose your job because of it? Yes, but severance is going to have to be paid. So you have to make that decision. But legally speaking, the only time you have that obligation to work overtime is if it says so in the employment agreement. Okay, so you'd have to look at the employment agreement, or I'm happy to look at it for you. So hopefully that makes sense. Terrible T, any questions, follow-up questions, issues, problems? I'm still here, or you can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that. Fantastic questions today, guys. Keep them coming, all right? I love those questions. I see more have come in. I'm not going to waste any more time. I'm going to continue answering them. Next question is from Janvier. I think I'm pronouncing it correctly. That's my French accent attempt on Facebook. Is there a form I can give an employer to tell the employer I only want to be here short term, like 3 to 6 months? Not sure what you're asking, or why would you want to do that? If you want to quit at some point, you could give notice of resignation. There's no need to give them a form or to tell them. It makes no sense, right? So if you work and at some point after a month, 3 months, 6 months, whatever it is, you don't want to work there anymore, you can give notice of resignation and leave. So that's the only way to do it. Beyond that, there's nothing else you should do. All right, Andy. Andy has our next question. Andy, I think, is joining us from YouTube. Andy asks, what evidence can a company use to recoup money if a severance agreement that included salary continuance and benefits called for the former employee to notify the company when a similar alternative job was obtained? So if you signed a severance agreement that says that I'll let you know if I find another job, and if that happens, you'll pay me less, and you don't do that, if the company finds out that you didn't tell them, and because of that they overpaid you, they can go after you for money. Now, what evidence? Well, maybe they find something on LinkedIn. Maybe they hear from maybe your new boss and your old boss go to lunch together sometime. Maybe you have a common connection that happens to mention, oh, by the way, Andy started working back in February. So it could be anything. They may never find out, but if they find out later, by the way, even if they find out 5 years from now somehow, they can go after you at that point. So it's a bad idea to do that. If you signed a severance agreement that says, I'm going to tell you if I find another job, tell them, okay? Don't play games with that, because you'll always be wondering, even years from now, is something going to happen? It's not worth it. But here's something else. Don't sign that severance agreement, okay? Not without getting advice, because chances are, number one, you're owed much more than you've been offered. Number two, that we can get rid of that condition completely so that you won't have to notify them. If you've already signed that severance offer, probably too late. If you have not, don't sign it. Not you, not anyone, ever. Not without calling us, okay? We can usually get rid of that condition and get you more severance. 90% of people, when they're let go, are offered a lot less than what they're actually owed, all right? A lot less. So please do the right thing, do the smart thing, and let's make sure you get the right severance. Andy, hopefully that makes sense. Does it matter how the company obtains the evidence? Absolutely not. It doesn't matter. Bad idea, though, to do that. Very bad idea. All right, next question comes from Heather. My manager told me I was going to too many medical appointments. I was a 29-year employee with a healthcare company. I did have more medical issues arise. Okay, well, first of all, if you're part of a union, you need to talk to the union. If you're not part of a union, by the way, everything I talk about today or anytime only applies to non-union employees. It does not apply. Nothing that I talk about applies to unionized employees. Nothing. Okay, only non-union. So, Heather, if you're not part of a union, there's no such thing as too many medical appointments. It's like saying, just don't be sick as much and we'll punish you if you're sick. It's ridiculous. It's nonsense. Now, here's the thing. If you can schedule your medical appointments off work hours, you should. Okay? It may be more convenient to go during work hours. I get that. But your employer can expect you to work. But if it's not possible, your doctor is only open from 9 to 5, so it has to be an appointment during those hours, that's fine. And you can't be punished, you can't be disciplined, nothing can happen to you. But again, you should try to make efforts to schedule appointments off work hours, evenings or early mornings or weekends, if that's possible. I have no idea if it's possible for you. If it's not possible, you schedule those appointments and your employer does anything to you, call me, okay? Employmentlawyer.ca to do that. Employmentlawyer.ca. It's silly to punish someone if they're sick and they need medical care. But again, try to find that off work hours if possible. All right. Beatrice Dot has our next question. By the way, if you just joined us, you still have time to ask questions about employment law and workplace rights with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I'm going to continue now with Beatrice's question. Ask yours as well. If your employer stipulates during the hiring process that you are on an independent contract, what sort of rights do you have? Should they pay taxes or do I? It's been 2 years and I'm still confused. So here's the thing. This is what we call a misclassification. Chances are, Beatrice, that the law considers you an employee, but your employer has misclassified you as a contractor. Why would they do that? Because they save money. They don't have to pay EI and CPP. They don't have to worry about withholdings, but it's illegal. If you look like an employee and act like an employee, you are an employee. And it doesn't matter what you signed. It doesn't matter what the company says that you are. If I have if I work full-time at a fast food restaurant, back in the kitchen, 9 to 5, Monday to Friday, and they start calling me an independent contractor burger flipper, that doesn't make me that. I'm still an employee. Same with you. So because you are an employee or should be considered an employee, your employer has the obligation to withhold taxes to remit to the government. But they're saying, no, you're not an employee, so we're not going to do that. The problem is CRA may disagree, so this may cause problems. So it's up to you. Do you continue working or do you leave because of this situation? Here's what I will say to you. If you continue working this way, and at some point, 6 months from now, a year from now, 10 years from now, they let you go, they're going to say you don't get severance because you're not an employee. But you are an employee, meaning you should be getting severance. At that point, you call me and I'll get you the severance that you're owed, okay? For now, you simply have to decide, do you continue working in this situation when the arrangement is likely illegal? Hopefully that makes sense, Beatrice. And any issues, follow up, you know how to reach me. So I mentioned for Beatrice, and before that to Andy, about severance and how much severance you're owed. Well, before I continue, I want to tell you and remind you how you can find out yourself right now in seconds how much severance you're actually owed. So easy. You just go to pocketemploymentlawyer.ca. You can see that address on the screen. Write it down, pocketemploymentlawyer.ca. And when you're there, you just click on the severance calculator. That's it. You're done. When you're there, you answer a few questions, and it's going to tell you how much severance you're owed. And you may say, well, why should I do that? I know I get a week or 2 weeks or a week per year. Wrong. All of that is wrong. You're owed a heck of a lot more than you realize, a heck of a lot more than what your employer is offering. Trust me, whether you worked for a few months or many years, the severance that you're owed is much, much, much more than what you realize. Check it out at pocketemploymentlawyer.ca. It's completely free. It's completely anonymous. No names, no company names. It's just there for you. If you don't check it out, you will potentially lose out on the severance that you're owed. Again, pocketemploymentlawyer.ca and click on the severance calculator. All right, let's continue answering questions. Fantastic. I love the questions. Let's see. I just want to make sure I haven't missed anything. Next question from Terrible Session. If a manager apologized for her conduct, yelling, swearing, belittling an employee after the fact, and then the employee warned her that she would escalate this if this happens again, should she still consult a lawyer or make some sort of statement to HR? Talk to HR always. Doesn't matter. Even if the person apologized, let HR know in writing what happened. They have to deal with it. Maybe they have to remove this person, discipline them, train them. Absolutely. If you're being mistreated by someone in the workplace, tell HR or whoever the right person is in your workplace. If the problem continues and the company doesn't resolve it, that's when you contact me, okay? employmentlawyer.ca, but always talk to the company first, always. All right, fantastic questions. Let's see if we get a few more questions in. You probably can ask a question right now and still get it in under the wire. Take advantage, guys. Ask that question. Harold. Thank you, Harold, for being here and asking a question. I've worked seasonal jobs for the last 10 years. My summer fall job is closing shop this year and I'm out of work. Do they owe me any severance? It's a small landscaping company, owners retiring. Absolutely. If you work there for a few years and you always kind of get called back, in season, and this year they're not calling you back because they're closing down. Yes, of course they have to pay you severance. So your severance, by the way, you can find out right now, Harold, how much that severance is. You just go to, as I said, to pocketemploymentlawyer.ca. See that right there? pocketemploymentlawyer.ca. Click on the severance calculator. But this is very common with seasonal jobs. You have a seasonal job, you're off, let's say, for the winter, and then you come back in the spring. You do that every year. And then one year, the company says, yeah, this year, we're not calling you back. Maybe we don't need you. Maybe we don't want you. Maybe we're shutting down, but we're not calling you back. Well, at that point, okay, they have to pay you severance. They don't avoid that just because the job is seasonal. So hopefully that makes sense, Harold. You can reach me, of course, so I can help you, because I assure you the company's not planning on paying you severance. There's no way they're planning. They don't know that they have to. So don't sit on this. Okay, let's connect as soon as possible through employmentlawyer.ca. Again, employmentlawyer.ca. All right. Let's see. Terrible T, I think, has a follow-up questions. I've never been asked to do overtime before. We have new management and they're plucking people last minute to do after hours work. It's difficult. I have children to take care of. So one of the things you may want to do, again, in writing, is send them a note saying, because of childcare obligations, I'm not able to stay late. I don't have anyone else to care for my children. If you do that, if you send that note, number one, they can't force you to work overtime, and they can't punish you if you say no. That would be a human rights violation. So that's the way to protect yourself, Terrible T, is just give your employer that that email saying, childcare obligations, because of that, I can't do it. As long as you do that, if anything happens to you, I'm right here, employmentlawyer.ca. Again, employmentlawyer.ca. Okay, let's see. Question here from Natasha. My ex-employee, maybe ex-employer, deduct UIF from my salary, but never paid it to the Labor Department. So I don't know what UIF is. There's no Labor Department in Canada, so I'm not sure. Maybe you're in the US. Can't help you. Okay, let's take the last question from Usual AD. I'm currently on probation, planning to quit due to extreme mental health issues triggered by this job. If I get a medical note from my doctor, can I be eligible for EI sickness benefits once I quit? Well, yes, potentially, as long as you've worked enough hours, okay? But you won't get it if you quit. You will get it if you go off on a leave. So one way to do that, if you've worked enough hours to qualify, is say, I'm going off on a medical leave, and then you get EI sickness benefits, and then you can decide whether you want to come back or not. If you just quit, you won't get EI, okay? Hopefully that makes sense to you. But again, depends how many hours you work. Did you work the minimum hours required to qualify for EI? You can find out online, and based on your situation, just Google that, how many hours you need to work to get EI sickness benefits. All right, that's the time that we've had for today. I think I've got all the questions answered. Again, I'm Lior Samfiru, the employment lawyer. It's always such a pleasure to be here and answer questions and hopefully make you feel better about your workplace rights. You kept me busy today. I love it. Thank you for that. I'll be back next week. My colleagues are also doing this almost daily, but please don't wait. If you actually need our help, beyond just answering questions, if you want us to help you get those workplace issues resolved, just reach me and my entire team in Ontario, BC, and Alberta through employmentlawyer.ca. Again, last time, employmentlawyer.ca. Thank you, everyone. Lior Samfiru, that's me. Wishing you a good day and good rest of the week. We'll talk soon. Bye now.